Good evening. We're back again, and today we're going to discuss the announcement or news reports that Florida Governor Scott has announced a program to drug test state employees. The announcement is troubling. If you see my previous video, which I called Drug Testing a Warning, you understood that I had prudential problems with drug testing, that I believe it's often a flawed process and puts good employees, good people at risk. There's something more, however, when that drug testing is imposed in the public sector. I have three basic areas of concern. First, as a matter of administrative law, apparently the governor is attempting to achieve this program by issuing what is called an executive order. Now, the proper use of an executive order in the executive branch is limited in circumstances. It can do one of two things, essentially. It can fill in the blank spots in laws that have already been written to prescribe what needs to be done. That's one thing it can do. And the other thing it can do is it can address areas that have not previously been addressed by legislation. As a matter of administrative law, the governor's actions are troubling because A, the state of Florida has a statute which provides for limited drug testing of public employees. And B, those statutes have extensive notice and comment regulations which have been published and which themselves are laws which control when, where, how, and why public employees can be drug tested. Yet Governor Scott has chosen to write by executive order procedures which appear to replace both statutes and notice and comment regulation. This is deep and disturbing because it seems to have little regard for the standard procedures for the rule of law. The other problem I have with it is constitutional. For at least the better part of 3 decades, the courts, starting with the Supreme Court and working their way down to the federal district courts in Florida, have limited the use of drug testing for public employees. They're not like private employees. Public employees can only be tested on 2 broad circumstances. One, when their jobs involve public safety. You can read that to be police, firemen, people who drive heavy equipment, and some other limited classes of people. And 2, when there's a reasonable suspicion to believe that the public employee is engaged in using drugs illicitly. If you go beyond these, you're going to have problems. Florida has previously been involved in litigation where it attempted to have rules that provided for broad testing of public employees, not within the strictures provided by established constitutional precedent. And the federal courts in Florida have restricted these programs and brought them to an end. And I don't know why Governor Scott's programs wouldn't meet the same fate. And again, I return to my third objection to them, and it's prudential. If you can check the other video, Drug Testing a Warning, I do not trust these drug testing procedures. They are, in many cases, almost fatally flawed, and over the long term, guarantee that almost any employee could test falsely.